Hello, good day, guys. Wonderful afternoon to you all. Happy to be here again, spilling the legal tea. So, welcome everyone. So, today we're going to be talking about revocation of petitions and category conversions. Okay, I'm going to be breaking it down, making it very, very simple for all of us to understand. So, join in. If you're watching on YouTube, you are very welcome. New family, comment, subscribe, like, and turn on your notifications. All right, guys. So usually when you file a family-based petition, sometimes, life happens. Life happens. When life happens, you have to be careful. Sometimes we make life happen. So depending on what's going on, you may want to be careful. Like, for example, you file a petition and then you go and get married. I'm going to be breaking it down, so please stick with me. So today, unfortunately, I will not be able to share my screen because the document from which I'm using it is on another device, so I can't share my screen. Okay. So yes, so many life changes may occur sometimes while you're waiting for a family-based petition to run its course, and you know that sometimes these things take anywhere from many months to many years, sometimes over 10 years. Okay, so even in the case of like immediate family relatives or in the shorter wait in the F2A category. So the F2A category is a family, the preference category where the spouse and children under 22 of a green card holder are being filed for. Okay, so if you're in the F2A category, it simply means that your spouse is a green card holder and you are, the spouse of the green card holder, and you have a child who's under 21 years old. Let me pull up. I just hope I can pull up the categories right here. The categories can be very, very tricky. So that's something that you always have to know, what category you belong to in order to be able to tell how long your application will take. Guys, I'll be reading comments soon. Okay, yes, so I'm right. F2A is spouses and unmarried children under 21 years old. Okay, so that's fine. So petitioners or beneficiaries may marry, of course. You may marry, you may divorce, or you may die, and the child beneficiary may turn 21. So take, for example, the F2A category, where you say you're a spouse or a minor child under 21 years old. Sometimes while you're waiting, the child may be, let's say, 20 years old or 18 years old at the time you file the petition. And then you guys are waiting. It may take sometimes 5 years. And then by that time, the child will be 23 years old. He's above 21. So what are the implications of some of these things? That's what we're going to be discussing. So all these life events, sometimes growing older, sometimes dying, sometimes getting married, sometimes getting divorced, have implications and impacts on pending family-based immigration applications. Okay, so sometimes these may derail your eligibility. You may be eligible at the time you petitioned, but because of a marriage or a divorce, you become ineligible. So, okay, let me see. The F2B category, for example, is unmarried. So the F2B, so there are preference immigrants categories. I'll do another video explaining all the categories, but remember that there's always the distinction. There's immediate relatives, that's the parent, child, or spouse of a US citizen. Then the rest of the people fall into preference category. So we're going to be discussing some of these things. So the F2B is the unmarried sons and daughters age 21 and over of green card holders. So if you're unmarried and you are 21 years old and older, and then you go ahead and you go and get married, you clearly take yourself out of the game, because the F2B category is only for unmarried, sons and daughters of green card holders. There's actually no eligibility for married sons and daughters of green card holders. So these are things you have to be careful of. If your mother is a green card holder and you are unmarried, you are, let's say, in Ghana, you're married as your mom is a green card holder in the US, and you are unmarried in Ghana, for example, you are 30 years old. As soon as you get married, you are no longer eligible to immigrate to the United States under the F2B category, because that's only for unmarried sons and daughters of green card holders. Married sons and daughters of green card holders, unfortunately, do not have eligibility to migrate to the United States based on, you know, their parents who are green card holders. Okay, so let's continue. So in these situations where life changes will wipe out your eligibility to immigrate through the family-based immigration, you need to be careful. Sometimes if you have already been approved, the approval will be revoked. Okay, so you have to make sure that in those situations you get to the United States first if you're unmarried, and then once your petition, it's approved and there's no more issue, then you can get married. You don't get approved and then pending immigration you go get married. That will cause problem for you. All right, so guys, yes, so sometimes some of these life changes, if you go get married, you get divorced, or your petitioner dies, or something happens, this may either lengthen your wait or shorten the waits you have. Okay, so we're going to be, we'll take a look at a few examples. As usual, we're keeping this short and sweet, so don't worry, we'll be done very, very soon. We're spilling all the US immigration law tea, so stick with me, guys. Drop me comments. I'll be reading comments very soon. So life changes, when we're talking about, let's say, a petitioner who naturalizes, this is actually good news. This is a great life change. So if you're a green card holder and then let's say you've petitioned for your spouse, so you're a green card holder living here in the United States, let's say in New York, and your spouse lives in Nigeria or Sudan or Korea or wherever, or Ghana, and then you've petitioned for your spouse, of course. So as a green card holder, if you petition for your spouse, the category is F2A. That's the second preference category. F1 is unmarried, children, or well, I should say unmarried sons and daughters of US citizens who are older than, yes, 21 years and above. Okay, so if you are F2A, it means you're a spouse of a green card holder. So you're in New York, you're a green card holder, your wife is in Ghana, and you've petitioned for her. Her category is F2A. While you guys are waiting, sometimes it could take 3, 5, 6, whatever years. Maybe in the 4th year, you become a US citizen. From a green card holder, you upgrade and you become a US citizen. That's fabulous news. And so once you become a green card holder, you, the petitioner, your naturalization would then convert your petition from F2A, which is the second preference category, to IR. This is the immediate relative. Those are the terms that I use. So you are no longer F2A, which is a preference category, but you are now immediate relative. So the preference categories, we have 260,000 roughly visas that are available for the preference immigrant categories worldwide. So this means that there's just a number of visas available to be given to these preference categories, and each country will split the quota. Each country has 7%. And so every year, this is yearly, so every year there's a number of visas available for Ghana, a number of visas available for, family-based Nigeria, Korea, China, India, all the countries worldwide. And so they are not allowed, the Department of State is not allowed to exceed the visa quotas. That's why there's a categorization. So if you are the family member, immediate relative of a US citizen, there's no visa quota. There's no number, there's no cutoff point for the visas available to these people. These are the top priority. So if you are the spouse, the child, or the parent of a US citizen, a visa is always available to you. There's no priority date issue. So if there are 1 million people who are family, immediate family members of US citizens, they can come at any time if their petitions are approved. But if you are, let's say, F2A, which is the spouse of a green card holder, you fall within a quota. And once you fall within a quota, if your spouse upgrades his, so let me say this. So for the F2A, it's 87,900 visas per year. That's the number of visas that will be issued for the F2A category. Okay. And well, let me not complicate things. Let me just keep it very simple. And so if you are F2A and you file the first part of the process here in the United States, as the I-130 process, and it's approved, your documents will be sent to the NVC, the National Visa Center. And then once you get the I-130, you get the priority date that will show you when you can apply. And so you have to wait for a visa to become available for your category before you can do the consular processing. So if you're an F2A, your wait is clearly long. But if your spouse upgrades and becomes a US citizen, now you become an immediate relative. You don't have to wait for your priority date to become current. If your priority date is unavailable, you do not have to wait for your priority date to become current. A visa is immediately available once the I-130 or the petition for alien relative is approved, okay? And so this is great news. This is an upgrade. And so your petition, your F2A petition, will now convert from an F2A to immediate relative, as I said, and there's no wait time. So that's great news. Okay, so let me go to the next thing. For example, also, if you are a green card holder, you file for a child, and of course, your child, your child is F2A. Okay, green card holder, your child is under 21 years old. Category is F2A. If you convert, if you upgrade to become a US citizen, the petition of your child, which is F2A category, will now convert to immediate relative. Your child is also an immediate relative, so no wait time. So this is an upgrade, clearly. Okay. All right. So for example, if you are a beneficiary, so the petitioner is the one who's seeking the US immigration benefit, and the beneficiary is the one who's going to benefit from the petition that's being filed. And so if your spouse is here and he's a green card holder, he's the petitioner who's filing for you. You as a beneficiary is the one who's going to benefit from the petition he's filing. If you are the wife of the green card holder, you will be the beneficiary because you are the one that's going to move here or going to benefit from whatever the person is filing. So if you're a US citizen and you petition for your unmarried child or for your adult son or daughter, what will happen is that the beneficiary, so let's say you're a US citizen here, let's say again you live in Maryland and you have an unmarried child who's in Ghana, okay? And then your unmarried child decides that, hey, I want to get married. It's allowed. I want to get married. So if your child turns 19, your unmarried child turns 19 years, and then they're eligible to get married, and then they go get married, what will happen is that if you're a US citizen and you are filing for your unmarried child or for your adult son, well, let's say unmarried child is under 21 years old, your child is unmarried at the time you file for them, so they are an immediate relative. No wait time. Visas are always available. If this child who is 19 years old, for example, goes to get married, then they get downgraded. They are no longer immediate relative, and now they have a longer wait time. And so they will become, they get downgraded from IR, which is immediate relative, to F1, which is the married child. Okay, so let me open this up. I just want to make sure I'm giving you guys what I want to give you. Okay, so for example, in this case, if the child is, let's say, no, let me find a different category. This, okay, great. Okay, I found it. So F3. So if your child who is 19 years old, he's an immediate relative, he's not married, and then he goes to get married, he immediately downgrades from IR, immediate relative, and goes to F3, who is the married sons and daughters of US citizen, any age. However, if you're, is this, it's a little, yeah, it's a little technical and complicated, so I'm trying my best to break it down. However, if you're a US citizen and you file for your adult son or daughter, okay, your adult son or daughter is in category F1. That's the category. If you have a US citizen adult son who's above 21 years or older, a visa is not immediately available. They have to wait. They fall within the quota, so they have to wait. So they are in F1. If they go get married, then they also fall to F3. Okay. So pretty much, I hope I've been clear. I hope I've not muddied the waters, but that's it. It's just really, really technical and very, you need to do a lot of calculations and understanding, because as I said, it's just the way of making things very complex, because and let me give you the backdrop of this. The number of people who are trying to come to the United States always exceed by like a huge margin the amount of space available for foreigners. Of course, the United States is the greatest country in the world, right? Of course, second to Ghana, because that's where I'm from. So second to Ghana. Well, that's quite subjective, because objectively speaking, many people view the United States as the best country in the world. And so the number of people who are always trying to come in the country are like millions of people. However, they try to keep the gates. It's a gate close. It's a gatekeeping mechanism. They want to keep as many people out, and so they've developed all these strategies and tactics to calculate the number of people who are being allowed into the United States. So these are ways to really, really minimize the number of people coming into the United States, to make sure that they can cater to the people living here in terms of medical amenities, social amenities like libraries, educational amenities, and like schools and all of that. Okay, so let's take this again. So if a US citizen files a petition for unmarried child or for an adult son or daughter, the beneficiary's marriage converts the petition. You, the beneficiary, you were filed for because you were unmarried. If you go get married, your petition will be converted from an IR, immediate relative, if you are the unmarried child, to F3. No, it will be converted from IR to F1 if you are the unmarried child. Okay, guys, this is just, it's really, yes, it is technical. As I told you that the US Government of Accountability Office, that's the organization that provides fact-based data to Congress. US immigration law is the most complex area of law in the United States. It's second to tax law. It's extremely, extremely complex. So there are just so many rules and lots of technicality. So stick with me and bear with me. So as I was saying, if, depending on the category, if you are IR, then you move to F1 or F3, depending on where you fall. So if you are a green card holder and you petition for your unmarried child or adult son or daughter, then your beneficiary, the beneficiary, marriage will revoke the petition. As I told you, there is no category for married, children of green card holders. Okay, so if you are married and you're the daughter or son of a green card holder, there's nothing for you. It's only if you are married and you are the child of a US citizen, there's a category for you, but not if you're a green card holder and they're the married child of a green card holder. Green card holders can only file for unmarried offsprings. So if you're a green card holder, you can only file for your children who are unmarried. If you're a US citizen, on the other hand, you can file for both married and unmarried children. Okay. Yeah, that kind of makes it clear. So let me just throw this in finally before we go. Tomorrow we'll continue. But if, for example, you file for a K1 fiancé petition and you go get married, the visa is revoked. There's no conversion for that type of immigration benefit. So be mindful of that before you take any kind of step. Please make sure you consult with your attorney, and then you make sure that is the right thing for you. If you have to wait, you wait, or whatever you need to do, you do. Call me 802-7800-564 and I'll be happy to assist you guys. I have to run off. Let's read a few comments and then go. Johnny Richard Nelson says, good evening. Hello. He says, powerful. Thank you so much. Miota Rima says, hello. Any heads up on pending asylum interviews? I wouldn't be able to tell what's going on. Have you already done your masters? Are you waiting for your merits or individual hearing? I would have to see, your attorney. I would have to see what you were issued with, whatever documents you were given to be able to tell or put in your A number to verify with the EOIR and check what your dates are. The dates are very, very varied. It depends on where you are located and what's happening. Okay, for 2021 cases, maybe I can do a video on that later. Frederick says, hi, Aunt Pokia. No, I'm just Poku, that's my husband's name. Please, you think the amenities will be possible? Oh, you mean the you mean the the US Citizenship Act 2021? Is that what you mean? The amendment of, how do I say it? I can't believe the word just keeps going away. I know what you're talking about. Oh my gosh, today I'm just out of it. I'm sorry. I've just been under the water the whole morning, just trying to finish up a whole lot of very technical work. So I'm just out of it. But he's talking about the what's going on in Congress with all the amnesty. Oh my goodness. Amnesty. Do I think the amnesties, the word amenities just threw me off. Amnesty. Do I think it will be possible? I've done tons of video on this and I keep giving you guys updates. So please stick with me. I don't know what's happening with these Congress people. The last update I did was on Friday. Let's see. I mean, I'm following it very closely. I'll give you guys an update as and when they become available. I'm really hoping. Fingers crossed. We'll see. All right, guys, I have to leave you and we will talk again soon. So call me 802-7800-564 if you need any type of US immigration law assistance, and then I'll be happy to assist you. All right, guys, have a wonderful rest of the day. I need to get off before I just clearly exhausted, right? Okay, guys, so I will speak with you all soon. Take care, be safe, and be blessed. Bye.